Those of you who don't know me, I'm Scott, and I am a big Star Wars fan.
Yes.
And so this feels very appropriate for me in the background here. I do want to introduce myself and say a little bit about my background.
Yes.
And the reason that Robbie's asked me to come in and talk is because I have this idea to give our digital personas protection. But what I like to call it is the Bill of Digital Rights. There are things that we just haven't thought about. And I've felt for a long time that we need to have a doctrine, something that enshrines protections for the individual as we go into the digital age. And I feel like the Bill of Rights is a very good model for individual protections. And so I feel like we need a similar type of document for the digital age. We need something that outlines fundamental principles that we should all be recognizing when we're looking at legislation, when we're looking at company policies, when we're trying to decide our own personal ethics in this technological world. We are just an asset. We are just a commodity right now. A way for businesses to make money. We have nothing we can point to say, you can't do that because this is me. And we do have that kind of thing in the Bill of Rights. We've built a government recognizing the Bill of Rights. And there isn't a law in this country that doesn't have to reflect on the Bill of Rights and be challenged if it's challenging one of those rights. And that's what we're trying to do here is we're trying to build a foundation so that legislatures can have the tools to protect individual citizens from being abused by technology as it iterates, as it gets bigger. I start with this statement that technology that exists for the sole intent of manipulating the real person for exploitation will not be condoned in our society. Technology that puts the digital persona at risk is not condoned. With that in mind, I've put together this 10 rights that I think are very straightforward. That we can start a movement behind. And I just want to go over the first one here because it kind of leads off to every idea. And that's the right to my digital persona. And what this is a real person has a right to any digital interpretation or abstraction of that real person. Essentially, anything out there that is represented as you, is you have the right to. But whether you've put it together or somebody else has put it together, that's you in the digital world, and you have a fundamental right to it.
So if somebody takes your picture and it ends up on Facebook, that's you.
That's your picture.
That's your picture. That is you. That is a manifestation of you.
My next right in here is default opt-out. You cannot be obligated into any particular activity at first sign up of any digital service. How I write it here is a user cannot be opted into services, solicitation, sharing of information, or sales. A person's opt setting can only be changed through a user's selection. For example, preferences cannot be changed by a service provider when they're making upgrades to their system or adding updates or change of ownership, like they've been sold to another company, or they decide to change the terms of service, or any other way that a creator might change a user's preference without a user's consent.
First, creator rights. Let's move on to the third one.
All right.
That's an interesting one too, I think.
So the idea of this stems also from blockchain. The idea is fundamental. The idea is you made something, so it's yours. There's no question about that. It's yours. And for anybody else to use it, they've got to get your permission. They can't show a court that I've given them permission. So they're already in violation of my digital rights.
So, okay. Number 4.
All right, this is
passive smart. I really like this one too.
This is one of my favorites. So passive smart is my branding for this idea. I've never heard it anywhere else except for out of my lips. But my thought is appliances that perform tasks that could be performed without a computer must be able to perform without a computer. The oven has to bake. The microwave has to cook food on a timer. The refrigerator has to stay cold. The washing machine has to wash clothes. The dishwasher has to wash dishes. Smart needs to be modular. Smart needs to be upgradable or not required.
So number 5, the right
to repair. So
to repair.
Right to repair is something that we hear a lot these days. Any creator that's making technology, whether it's hardware or software, has a fundamental responsibility to be responsible for that technology. That if you're going to bring something into our society, you're going to be responsible circulatorily removing it when it's no longer necessary or desired. If it's no longer going to be used, if they're not going to maintain it any longer, they need to provide that information so that other people can maintain it. It'll fall into the public domain. And that goes right into the next one, the right to reuse. And the reason that I've separated them is because this should really fall into the realm of software as well. It's been one of the most frustrating things being a tech person, being a computer person, is watching as decent software is abandoned by companies to go out of business. So if they're going to continue to make obsolescent products that have built-in obsolescence, well, then they're gonna reap the errors of their ways, because we're going to hold them accountable when they don't make them available to be fixed, when they don't provide us with the information so we can maintain them ourselves. There is a class out there of fixers, and they have been the ones that have kept our stuff going.
Oh, absolutely.
And what's happening right now is appalling. I have talked to appliance repair guys that have lists of name brands to stay away from because they're watching them fall apart within months of purchase.
Number 7, ISP failure fallback.
Disappointing that so much of the internet is reliant on one connection or two. You go into any internet market, there's always one or two internet providers. There isn't 6. Thank God for Starlink, because all of a sudden every poorly supported internet provider in all areas has an alternative. So basically your backbone in any circumstance should have 2 backbones. And the secondary backbone should turn on at least the minimum bandwidth that a community has decided must be guaranteed. So
number 8,
the right to remove. A service must remove any data a user has shared with that service on request by the user. We're essentially saying what we were saying before. I'm in charge of my digital persona, and services have to respect that. Service must provide a means for a user to collect and download all data they've shared with that service. You've already watched this happening. We don't have regulation in the United States for this, but they do have it in the European Union.
Let's say you've had a Facebook account for 15 years, right? And you've uploaded your entire life pictures of there. And then at some point in time, Facebook decides that you have perpetrated misinformation. And there's a lot of people that get on the wrong side of that. And if they're permanently banned, they have no recourse. They have no way to get that stuff back. A lot of times it's just going to be gone. Yeah.
And so this right to remove is also a right to receive, to always be able to get data from that service.
All right, number 9,
the right to defend.
Yep.
This to me is intuitive, but it's not enshrined as a protection. And I think that we would be better off if it was a fundamental right, a principle that everyone has to follow, is that there's nothing illegal about defending your digital persona against malware, spyware, eavesdropping, spying, adware. It needs to be perfectly acceptable, perfectly legal for me to set up blockades, run ad blocking software, require extra authentication, anything that I have put in place to protect my digital persona from being exploited should be considered legal. It's considered an arm. Kind of like the right to bear arms. You have a right to defend your person, and you can use all legal pieces of technology to do that.
Number 10.
This is a right to digital privacy. And I like how this reads, so I want to read it verbatim.
Okay.
Everyone has the right to freedom from solicitation. An unsolicited email, phone calls, chat messages, and so on are violations of your digital rights. Registering on a no-call list must override any individual request for solicitation by any services. The no-call list must have a default and allow for exceptions that allow a solicitation service to present options to a user. The reason I've written it like this is because I recognize, we all are familiar with what a no-call list. It's been very ineffective. If we put this into the Digital Bill of Rights, then every time, every logged phone call, every junk email that you're intending to block that still comes through is a violation of your digital rights. There can be, because of that, because of the nature of your rights being violated, there will be some kind of repercussion. The United States was founded on the Bill of Rights. Our Constitution was built on it.
It's founded on fundamental freedoms.
That's right.
Unalienable rights. And the government cannot make any policies that violate these rights.
But this does feel like a good foundation for governments and businesses and for our own personal ethics to start from. This principle, very much similar to the Bill of Rights. You were trying to say it before. The rights are not given to us by the government. They're guaranteed. We always had these rights. And the Bill of Rights guarantees the government can't touch them.
Correct.
It's making it clear that it's recognizing that these are areas that the government can't do. And then they have to work from that foundation.